Welcome to Clause 8, the voice of IP, hosted by Eli Mazur. Qualcomm is responsible for what was thought to be impossible, the smartphone revolution. Besides everyday users, one of the biggest beneficiaries of Qualcomm's technology was Apple. Apple relied on the technology to make the iPhone that grew its market cap to a record $3 trillion. Eventually, Apple decided it was paying Qualcomm too much for the technology. And instead of agreeing to one fair arbitration process to settle the dispute, Apple decided to rely on scorched-earth litigation. The dispute between Apple and Qualcomm quickly blossomed into more than 100 cases around the world. But it wasn't long before Qualcomm was racking up wins in China, Germany, and the US. Apple finally agreed to settle on the eve of another trial in the US back in 2019. Bob Giles was one of the people responsible for that Qualcomm victory. 2 years after that, he was named Chief IP Counsel at Qualcomm. He now shepherds a team that is responsible for managing and growing 140,000 IP assets and handling some of the most high-profile patent disputes in the world. On this episode, Eli talks to Bob about his new role and the ongoing disagreements between innovators like Qualcomm and implementers like Apple. Bob also shares priceless advice on all kinds of topics. Clause 8 is part of IP Watchdog and sponsored by Harity, the go-to firm for the Patent 300 for patent preparation and prosecution. A special thanks to Hunter Yancey and Tim Herzl of Qualcomm for making this interview possible. And now here's your host, Eli Mazur.
I'm going to get a few disclosures out of the way. The first one being is that my firm, Harity, does patent preparation and prosecution work for Qualcomm, and they are one of our favorite clients. And the second disclosure is, on a personal level, obviously extremely grateful for the smartphone revolution that Qualcomm helped usher in. My wife might say a little bit too grateful. Thank you so much for joining, Bob.
Great. Well, thank you very much for having me.
What does Qualcomm think is its core business? What is it really about?
Qualcomm was really founded on, kind of creating a better cellular communications technology. So, back at the very beginning, there was a small group of people, led by Irwin Jacobs, and they were trying to figure out a better way to communicate. And they came up with kind of an implementation in the CDMA technology that is really kind of this the story just reminds me of kind of the quintessential American success story, right? They came up with the implementation. They tried to convince people that it was going to work, and there's publications out there. It's pretty funny. You see people commenting that it defies the laws of physics, and there's no way it's ever going to work. And
yeah.
Really, the true naysayers came out, right, and really tried to suppress the technology. They persevered through it all, and they had to actually demonstrate initially with prototypes, but then eventually in kind of commercial context as well, that the technology would work, right? Because there were so many naysayers, so many people that they had to do everything from end to end, right, from the network side all the way through the communication channels to the phone, making sure that everything was working, the mobility aspect of it was all there. We have a Qualcomm museum downstairs, which has a cutout of the first van that they were driving around town to test everything out. And so they had to do everything, right? It was a total proof of concept from the ground up. And not only that, they with respect to the IP rights, they were actually able to keep the lights on through a very initial license agreement they were able to get into with AT&T and Motorola. And Irwin tells the story obviously very well about how they were debating how to pay employees, how to keep the lights on, and then this licensing agreement came about. They were able to enter into it, and actually that kind of pushed them into the next phase, where they were able to then reinvest and push forward with all the commercial deployments and commercial tests that allowed them to demonstrate the effectiveness of the technology.
Well, you mentioned that in the beginning, to prove that it's going to work, they had to make all the products themselves from end to end. Yeah. Why didn't Qualcomm kind of stick to just making the products themselves?
Interesting cycle, actually. So we had to make everything from, this was obviously before my time, so I'm speaking in the royalty, from the base station side of things to the handset side of things, the chips, everything that goes into it. They had to make everything to prove that it would work, because they didn't have any partners at the time. And so Qualcomm spun off its networking business, and then actually also did the same with the handset business, so that they could really focus where the core was, which is on the R&D side, and essentially, continuing to be the R&D arm for a lot of the cellular industry, right? So that people could build off their technologies. So that's why I think they kind of focused where their core was. And now it's a little bit interesting because we are actually getting back into some of the networking side things through the femtocells and some of the new networking technologies that are coming out, disaggregated RAN and things like that.
And you mentioned that Qualcomm was able to survive because of a licensing deal with Motorola. A story that I recently found out was that Apple was able to survive because of a licensing deal with Microsoft. So they have that in common. And obviously, Qualcomm is now focusing on research development, like you said, to enable all that telecommunications technology, allows everybody else to make these end products and provide these services. But what role do patents play in that?
So patents play a number of different roles in this context. So one is they actually allow us to collaborate, in the industry, because we know that our IP is going to be protected, and so we're not afraid to enter into collaboration agreements to work in the standards organizations like we do. And it also kind of, the trade-off with patents is you disclose your technology, right? And so it allows us to be a lot more open about what we're doing, about some of the R&D efforts that we have, because we know they're going to be protected in the end, and we're going to be able to retain the rights to our intellectual property. So in that respect, it does allow for quite a bit more collaboration than would normally occur without a patent system, because we would have to be a lot more guarded, a lot more sheltered, not share our ideas as broadly as we can. And so that's in the the R&D phases, but it also allows us to disclose our technology so that other people can build on it, right? Other companies can then build on some of the R&D or on the R&D efforts that we've put in, that our engineers have put in. And so it allows kind of this perpetual growth in R&D instead of keeping it all trade secret or much more confined and just trying to do it all ourselves.
So right now, the business model, what I understand, and correct me if I'm wrong, is that Qualcomm comes up with all of this technology for this phone. I'll say a phone manufacturer comes up with this box. Qualcomm gets, I don't know, under $10, and then the company that comes up with the box sells it for $1,000. I'm exaggerating a bit, but it's like 5% towards 95%. Do you think that's fair? And why does that make sense for Qualcomm?
So the business model is, to do some of that very, very early R&D, right? Take the chances, take technologies that are going to be trying to answer questions that haven't arisen, in the industry yet, right? Trying to solve problems that aren't out there. So what our engineers are doing is trying to think about, okay, what are the problems that we're going to see in 5 years, in 10 years, and trying to solve those problems. We obviously patent that technology as we and our solutions as we move forward, and then we disseminate it right to the industry. Yeah, and the kind of the trade-off is we're able to collect then a royalty on our foundational research that others are able to build off. So I do think the system works well. I think it's a great system, and others that can't put in the efforts of all the R&D, the trials and losses, the solutions that aren't quite as effective as we'd like, or maybe not work at all. Other companies don't have to sink their resources into trying to solve these problems, and they can then focus on building off of the technology that we then license.
If I was a billionaire thinking of entering the telecommunications industry, and I'm looking at it and I'm saying, should I enter a part of a market where I do all this, like you said, early research and development, don't know what the payoff will be, and then I will get this tiny fraction? Or should I try to just make these consumer products based on that once it's successful and see, if I can get that much bigger share?
Sure.
The system as it stands, do you think it incentivizes the right investments?
I do think it incentivizes the right investments because we're able to collect that royalty off of our R&D, right? Whatever business model others may have entering the market, I think there is a very strong incentive for companies now, because of the patent system, to take the risks, right? To do the early R&D, to try to solve the problems that are going to arise in the future, and I do think there is an incentive there for it.
So I want to talk a little bit about the practical impacts. You talked about one of the things that the patent system allows us to do is to participate in these standard setting organizations and kind of collaborate through that. But, on a practical level, the way it works is that there's a lot of these companies that are come up with their own technology, and then they have to kind of agree to what's the best technological choice, right? And on a practical level, do you think that works well? Or do you think there's some other incentives at play? And then do you think the reward aspect, are those the companies that are actually contributing, getting compensated fairly based on that?
On the first question of kind of how the process works, I actually do. I'm not in the standards meetings and kind of banging through everything, but I have a lot of interaction with our standards engineers, and that system seems to work well, right? Put your where everybody kind of comes together, reviews different solutions, tries to figure out the best technology that's going to move the industry forward. I do think that system works from all accounts that I can gather. So, having these vetting sessions, for lack of a better word, right, at the standards organizations where you're trying to prove that your technology works, and works better than other solutions, right? I do think it's a good system, right? Because the best solutions are able to percolate to the top and get adopted then. And so on the second question of the reward for taking all of this, I do think that I would always say that we should be able to reap a little bit more of a reward, but I think things are working out just fine.
Do you have any concern, I guess, about bad actors kind of gaming that standard setting organization system?
There's some legacy of some legend, I guess, of some things happening in the standards organizations. I think overall, though, it seems that the system is working. There are some. I have definitely heard some stories about people changing votes and things like that, but it's a very, very, very few and far between that things like that happen. From everything I've been able to gather, and so because there is the way it works now is there are large multinational corporations that are based in different jurisdictions that are all kind of contributing. Those issues don't arise nearly as much as people think.
But actually, going to that point, I assume a company that's operating in the U.S., an American company, might have a different set of values than a company being controlled by an authoritarian regime, for example, that participates in those organizations. Is there any risk to that kind of, to opening up our technological advances?
So I think the risk is actually the opposite. I think that the risk of creating, the way it works now is, there's a kind of a more uniform standardization process, I would say, across the world. And there is a risk that, that's going to get broken and you're going to get fraction standards and fraction standard organizations that are then kind of just purely manipulated by regional concerns and things like that. I think that's more of a concern than kind of if everybody's still glued together and still working together, as it is now.
A big debate in exchange for entering a standard setting organizations, the contributors have to agree to license their standard essential patents on a fair, reasonable, and non-discriminatory basis. I guess you would call the companies that actually license those patents have a lot of complaints about them, and I just wanted to go through them and get your thoughts about them. One of them is that they complain about is, they say, royalty stacking, and there's way too many. I know I'm a $1 trillion company, but there's way too many of these companies that I have to deal with to make this product. They're all asking me for license fees. It's a crazy world. It's distracting me from what we else could be focusing on. Do you think royalty stacking is an issue?
I haven't seen any evidence that sways me to believe that it's a serious issue, and quite to the contrary. There's articles, I believe Jonathan Barnett has published articles on this issue where he's empirically demonstrated that price of the technology that people are licensing is actually much lower than he would expect, from his analysis. And so I think quite to the contrary, I haven't seen any evidence that there is a royalty stacking problem.
And another claim they make, the owners of a standard essential patents, they over-declare, meaning they claim they have a lot of standard essential patents that aren't, and then a lot of their patents are invalid. Do you think, and I'm not sure if there's any way to fairly quantify that or that, what do you think about their claim?
So as for the over-declaration issue, well, for one, most companies that are in this field are fairly sophisticated, and they kind of understand which technologies are important for the standards and are implemented and things like that. So for bigger, sophisticated companies, however many patents are declared, it doesn't seem to be an issue. But two, there's a time frame where you declare your patents, where a lot of times the claims aren't set, the standard isn't set quite yet. So you don't know if it's going to be standard essential or not standard essential, and so the declaration process is to kind of declare patents that you think may be, I think the language is are or may become standard essential, and so it's a bit of a speculation as to how the patent is going to end up, and also how the standard, where the standard is going to be set. And so, to err on the side of caution a little bit, companies do declare a little bit earlier, and so there are patents that end up not becoming standard essential. But that's not what the obligation is, right?
Correct me if I'm wrong. My understanding is just because a company declares it to be a standard essential patent doesn't mean they're going to be collecting a license based on that.
Yeah, not at all. And it also, I don't like to say, I don't like to use the phrase declared standard essential patent, because really what you're declaring is that it's a potentially standard essential patent.
Well, what about, I guess, the invalidity part? There's claims that 80% of all patents are garbage, blah, blah, blah. We need to litigate each one at the PTAB until we prove the value.
So on the licensing side of things, it's kind of viewed in different contexts, right? If you are going to have to challenge every single patent, prove that every single patent is valid, and before you get into a licensing deal, it's just not the way that rational actors act when they come to the table to think about licensing especially a large portfolio of patents. Most rational actors look at it; they'll assess maybe a subset of the patents themselves, and kind of make a determination that, okay, look, we probably should license these assets, and not not go through all of the transaction costs of trying to invalidate every single one of them and getting it down to a certain niche. And so I just don't think it's a way that kind of rational actors act when they're in this situation.
I'll buy that, but what about rational actors still says, well, half of your patents are invalid, or we should make an assumption that a huge subset of your patents are invalid. Implementer's point is, if I understand it correctly, is that assumption is not made.
So if you're going to make an assumption, though, that a large portfolio is a certain subset of it is invalid or not infringed, I mean, don't you have to make the corollary to that, which is you assume that a good chunk of the portfolio is valid and infringed, and that you need to take a license to it. So I think discounts on large portfolios just under that context don't make a lot of sense.
These debates, they've reached, I guess, the highest levels of government as much as patents can. One of the manifestations of that has been these joint policy statements that happened in 2 administrations ago, that happened in the last administration, in terms of what should be the remedies for standard essential patents. Should injunctions be available for them or not? What do you see of these kind of going back and forth between each administration? What kind of impact does that have? Each administration seems to be going in a different direction when it comes to that.
I guess so. There has been a little bit of a change kind of in direction, and hopefully it kind of equilibrates, and kind of the pendulum doesn't swing as far every time. It would be nice. But as far as whether or not injunction should be a viable remedy for SEPs, I do think they should be. There's definitely clear situations where they should be allowed, right? When you have a potential licensee that's obviously kind of running out the clock and not acting kind of in good faith, there is a good faith requirement here, both on the licensee side and the licensor side. And if they're not acting in good faith, if they're found to infringe, valid patents, and they haven't, and they've also been found not to be a willing licensee, in that situation, it's very clear that an injunction should issue. And so I don't think that injunction should be taken off the table altogether for SEPs. That's for sure.
We're going to talk a little bit about the Apple versus Qualcomm litigation, and that's how you spent a lot of your time at Qualcomm, and then you became Chief IP Counsel. Talked to a lot of patent attorneys, and when you ask them what their dream job is, they say Chief IP Counsel. And I don't think any of them imagined being Chief IP Counsel at a company like Qualcomm, where patents can play such a role. Do you remember when you started thinking about becoming Chief IP Counsel?
It definitely wasn't at the very beginning of my career, I can tell you that much. And so it wasn't until actually fairly recently that, I thought it was a good time, a good place for me, and that I could contribute kind of greatly to the company's objectives. And so I have to say, because kind of earlier in my career and kind of at my beginning stages of my Qualcomm career, I was with the litigation group, right? And so I was on the litigation side. And obviously I worked very closely with the IP department the entire time. I would take trips over to China where it would be me essentially and 10 to 15 people from the IP department, headed over there to prepare for something. And so I obviously worked very closely with the IP department, and kind of I think the position and my growth at the company kind of just matched at the right time. And the opportunity arose. And so it was a good fit.
What is your role? What does it mean to be Chief IP Counsel at Qualcomm?
Incredibly fortunate to be kind of a shepherd of this unbelievable portfolio, and both on the patent side, but also we have other IP on the copyright trademark side, and a lot of other issues that the group has to deal with. So my role, the way that I've looked at it, is to help the department to become successful, right? And you have to define what success is and figure out how to go about that. But the role that I kind of envisioned for Chief IP Counsel is really making sure that we have the resources we need, making sure that we have the direction we need, making sure that people are kind of focused in the right areas, and through that, kind of hoping to ensure that the group is successful going forward.
How do you think about what kind of work Qualcomm should be handling in-house versus outside?
Obviously, we have our own attorneys in-house all over the world now. We have people in China, the U.S., obviously, India, and in Europe as well. And so I have thought about this kind of division of labor and what should the in-house crew be focused on. And so in-house here, we're a lot more in tune to the kind of the needs and the direction of the business itself than an outside counsel would be, right? So making sure that outside counsel is doing the right things as they're drafting patents, for example, reviewing the patents with an eye towards what our business actually is and where our business is going, as opposed to, maybe an outside counsel doesn't have as much insight into that and so they might be drawing narrower claims, narrower specification, or focusing in areas that kind of don't mesh with our business objectives. And so I do think that's a big role, or a big division between kind of in-house and outside. That said, I really appreciate and I really search for and like our outside counsel to be as in tune as possible with the business goals, with Qualcomm's business goals. And so that outside counsels, relinquished to that duty, because I do think they play a key role in it. But I just think the in-house counsel needs to have a laser focus on it.
And you mentioned how you used to focus on patent litigation before you moved to Chief IP Counsel. What has that transition been like?
So the transition, I think, has been great. So I came over, a year ago, and really I've spent the last year talking to everybody in the group, right? Really kind of getting to know from a different perspective, right? I worked very closely with the IP department, with a lot of people in the IP department for, the whole time I've been at Qualcomm. But obviously this is a bit of a different perspective, right? More of a managerial aspect. And as I said before, I don't know how to help the group be successful if I don't know kind of where their issues are, right? And so I did spend the first year, and I'm still doing it actually now, just talking to everybody. Having tons of one-on-ones with people in the group, having small group meetings, with a bunch of people, and I kind of joke around that when I was going through a whole stream of the one-on-ones, I was joking that I hope it's not quite as bad as the meeting with the Bobs, but and unfortunately my name is Bob, which made it even worse. But that was kind of what I was trying to do is just understand the inner workings of the group and all the issues that they face and so that I can kind of better look out for try to fill some of those needs. So I think the transition's been good, and I've actually. Obviously, I was a little nervous about kind of moving over and taking on the role, but I've been just unbelievably happy with the group. The group and everybody in the group I just think we have such a top notch talent, and it's been a great transition though.
Yes, it seems like you're really enjoying it. Has there been a part of a job that you found difficult or kind of keeps you up at night?
Keeps me up at night. So the one thing that I think keeps me up and will always keep me up is just making sure that we can do everything that we can to produce the strongest patent portfolio and IP portfolio in general that we can to support the company. That's always going to be in the back of my mind. What else could we be doing? Should we be focusing here, focusing there? Are we, obviously, in the patent world, it comes down to very small detail and claim language, right? That can make or break a case. And so, making sure that people stay hyper-focused on, all the details that we need to be focused on.
And that's interesting because I thought, especially since you're coming from the litigation side, I thought you'd say it's whatever high-profile litigation is going on and whatever motion needs to be filed in that case. But it's interesting. You say it's really that work you do beforehand in terms of building that portfolio.
Yeah, and it's a mindset that the team has, and I try to amplify it every time I can. But we're generating assets and capturing the IP of the company that's going to be used later, right? Everybody has to have the mindset that I'm going to litigate this patent in 2 years, in 5 years. So I want to make it as solid as I possibly can at this phase, at the prosecution phase, because that's where it's all built. Those are the building blocks that need to be there, or else you can't effectively assert the patent later.
Your Chief IP Counsel role isn't the same as, let's say, a Chief IP Counsel at a big insurance company, or where nobody might know they even exist. I mean, how does that shape your role?
It is. I'm incredibly fortunate to be, Chief IP Counsel of a company that respects and values IP as much as Qualcomm does. We are integrated. Me and the team are integrated with the engineers. We get to sit in design reviews. I get to sit in high-level meetings on kind of planning strategy about where we're focusing our R&D and everything else, and which is just an incredibly fortunate place to be. For example, I was in a meeting the other day there were about 6 of our top cellular R&D people in the meeting, and just discussing kind of what their vision is for 6G and where are we going to be going, 10 years from now. And, obviously I was a fly on the wall in the meeting, but it was just so awesome to be able to sit there and listen to these discussions unfold.
Speaking of your portfolio, obviously it's a theme about how important it is. And you mentioned engineers who are obviously, without them, there would be no portfolio. I mean, how do you kind of get the engineers to appreciate the importance of the patents to the company? Because I'm sure they just want to come up with the next idea, right?
Yeah, but I have to say that the mindset at Qualcomm is a little bit different than other companies. And I've come to realize this. Well, I knew it, but I didn't, kind of see it firsthand, that we've the various different mindsets of talking to people that are other companies on kind of how they patent just purely defensively. They don't think about, they have to actually go out and really prod people to submit IDFs, right? So they can kind of fill the pipeline a little bit. Here, like I said, we are my team is in various different groups are embedded with the engineers, quite significantly. And so IP is on people's minds. And we have a chance to ask during or after the meetings, right? We try not to interrupt, but, after the meetings, reach out to one of the engineers that had an idea during the meeting and say, hey, look, I think that was actually a really interesting idea. What else are you guys doing along these lines? And we should maybe capture some IP in that. We'll help them kind of submit the IDF and take the process from there. So it is quite a bit different than it is at most other companies, I'd say.
Yeah, that's interesting. I think from that I got it's the ability to really embed your patent attorneys at such a level where they're kind of aware of everything that's going on. That kind of makes it easier for the engineers as well. One of the interesting things, and you said what keeps you up at night is kind of making sure that Qualcomm has a patent portfolio that it deserves and can put it in the best position. How do you decide what needs to be in that patent portfolio? One of the interesting results of that, I guess, the Apple Qualcomm litigation, that I think the 3 patents that were found to be infringed were the non-standard essential patents, right?
Yes.
So how do you view, this is what we need in our portfolio, standard essential patents or non-standard or nothing to do with telecommunications?
So we definitely do keep a mix, right? Our portfolio is not just purely standard essential patents. The non-essential patents or the non-standard essential patents are also very important. And so kind of where to draw those lines and how the mix kind of unfolds over the years has been something that we've been dealing with. I've been dealing with it obviously a lot more now that I'm in this position. I have a very critical eye towards the non-essential patents and the importance of those patents as well, obviously for the company, but and as the company grows, right? The company's growing in many different directions, and so and we're getting into many different industries, and so I still think that I do think that the non-essentials play a critical role in the kind of the business objectives of the company.
How about for those new areas that Qualcomm might be getting into? How do you think about how much to invest in building out those different portfolios? For example, I've seen Qualcomm products they sell at the stores, power chargers or stuff like that. Not direct related to cellular technology.
Quick charge. So we've actually gotten ourselves into a whole new world of anti-counterfeiting quick charge stuff that we haven't had to deal with in the past. So just to step back a little bit, it is an incredible time to be at Qualcomm right now, and especially in the IP department. But because the company is moving and broadening and its scope dramatically over the last couple of years, and the roadmap for the next few years is even bigger. So, which for the IP department, it gives us a lot to think about, right? What type of portfolio is needed in the auto industry for $1 billion auto business, right? And what portfolio is needed for some of the IoT areas that we're pushing into? I think we now have $1 billion IoT business as well. Don't quote me on those numbers. They may be off a little bit, but we have a very substantial IoT business now. And so, what does a patent portfolio look like in those areas? And you have to assess, right? Is it a potential licensing avenue down the road? Is it a pure defensive play? Is it what types of areas are we pushing into? How litigious are the other players in those areas? These are all questions that we have to ask. And are we going to be in direct competition with a company that's pretty litigious, that may counsel towards having a bit more of a patent portfolio or other IP portfolio in those areas? So,
you mentioned, you want your in-house counsel to kind of think of every patent as a patent, or outside counsel as well, I'm sure, as a patent that's going to be litigated. So obviously you want it to be valid and, read on something, not just be something that will never happen. How do you think about the quality control in terms of on your patent portfolio?
So there are kind of mechanisms that we've put in place, along the lines of, just to describe it very generally, as a kind of more of a peer review type system. We obviously check for errors and things like that regularly, but we also do kind of much deeper dives on the peer review side and vetting side on specific areas of the portfolio. And so with that, it's kind of a process that's mostly in-house folks doing it, kind of pressure testing the patents a little bit as, kind of in the various stages as they go through. But I think it's extremely valuable work to kind of take on those efforts so that when the patents are issued, when they come out or continuations are filed, or we're able to see that we should file a continuation in a certain family. I think it's incredible valuable work to do that as the patents are moving through the process. So we obviously can't do it on every single one. We have 140,000 plus assets right now, so we have to be selective and make sure that we're kind of sampling around the various areas of the portfolio.
That is kind of the balance, right? Because you have to do it at scale efficiently. You can't hold a mini litigation for each asset. I mean, how do you balance that other end, I guess, to make sure that it's somewhat efficient in terms of the value that Qualcomm is getting?
That's kind of the line that we've been drawing. We're trying to do it as much as we can, to be honest. And really, the controlling factor is our resources, right? And so we do it as much as we possibly can, with the resource constraints that we have.
One of the things about obviously just being in the legal world but even in the patent world is that, the law changes. What our understanding of the law changes all the time. Maybe you're a litigation, a federal circuit decision, or a licensing negotiation or anything like that might make you think differently about what's the best quality of patents. How do you maneuver your in-house counsel and outside counsel to react in the proper way to this kind of changes?
So this is the billion-dollar question for an IP department, right? And not only do we have to deal with Fed Circuit law and district court law, we also deal with changes in the law in China and in Europe and in India and everywhere else that we have. All over the world. And so it makes it, exponentially even more complicated. You have to take an approach to things. Well, first off, you have to be knowledgeable about what's going on, right? And I expect my outside counsel to be knowledgeable about what's going on. I'm pushing, especially outside counsel, well, in-house and also outside counsel, to be also knowledgeable about what's going on in the rest of the world, the IP world, in other countries, right? Because when we draft an application, we have to draft it and file it with, kind of a worldwide perspective in mind. You can't file it under, and do everything that you need, dot the I's, cross the T's for the US, because you may be hurting yourself in another jurisdiction. And so it may or may not, depending on how you file it. And there's other considerations that are taken in China or Europe, for example, that we don't take into account here in the US. And we need to make sure we're getting that into our initial specifications, or we won't have the support going forward. So first off, you have to kind of have the knowledge of what's going on around the world. You can't be super reactionary. Obviously, we're dealing with longer time frames here, but you definitely have to be aware of the trends, right? You can't react to one specific case, but one specific case that's an outlier may become a trend. Hopefully, it doesn't if it's detrimental. But then you have to follow the trends and make sure that we're kind of taking those into consideration as we're prosecuting the patents.
I encounter a lot of in-house counsel companies where they basically tell me they get patents and then they just sit on the shelf. They don't know what to do with them. And they're trying to figure out, well, how do I kind of do things more in line with what you do? Or even a new Chief IP Counsel, first person in that company in that role. And they're like, all right, I want to build a company where we get patents that actually read on products that are valid. What would your advice for them? Like, where do they start?
So this is actually a process that I've been undertaking in addition to learning everything that the team has to do, is also learning much more granular level about what our portfolio actually is, right? And so I pull, if the teams are working on pulling apart the portfolio, really analyzing it, trying to figure out how we would use it, and then, maybe even putting it back together in a slightly reconfigured manner, right? And so we're actually doing that right now, and it's been a great process to go through this, because we are actually realizing that if we merge assets in a different way, or thinking about it a different way with the target in mind, that we actually have a larger portfolio in that area than we actually expected that we did. And some areas it's also helping us kind of figure out if there are gaps, right? Maybe we need to be reaching out to other engineering teams and trying to figure out if they're just not submitting IDFs and they really do have some technology that they're creating. So that's, the first step is understanding what you have, right? And also what direction the company wants to go, right? If, like I said before, sometimes, it's a licensing play, sometimes it's a defensive play. There's other aspects. And so you gotta kind of match what you have in the portfolio with what the business directives are. Does the company have a mindset to start licensing some of the portfolio, or is it just a purely defensive play?
Obviously, you mentioned you were involved in the global litigation of Apple versus Qualcomm. I think it became one of the first, or maybe the first in a wave of global patent litigations between implementers versus innovators. Was this type of dispute with Apple inevitable, or was there kind of an alternative history where Apple and Qualcomm could have been happy together?
I don't think it was inevitable. I think obviously I wasn't in any of the backroom meetings or anything discussing the actual relationship, but I don't think it was inevitable. But it definitely turned into quite a battle. That's for sure. So
starting from the litigation point, obviously it took a long time to come to that final deal. What do you think that kind of prevented Apple to say, let's sit down and make a deal in the beginning the way they were able to do it?
There are companies, that just have a mindset that they're going to fight and not pay for IP. And so that may have been their mindset going into it is look, let's see how much we can grind and see where it goes. It seems to be the mindset. Some of your previous guests, Josh Malone went through, right, all the trials and tribulations with a bunch of balloons that he went through, right, and the Telebrands litigation, and it's all true, right? Telebrands just had the mindset they didn't want to pay, and they weren't going to pay until somebody absolutely forced them to. So that's the mindset, kind of that holdout mindset that a lot of companies have. So
from a practical standpoint, you're dealing with one of these kind of opponents who has like endless resources or relatively endless resources. I mean, how do you plan the strategy to coordinate to kind of get them to a point where you'll have a positive outcome?
Yeah. So, I mean, in that case, we filed cases all over just on the patent side, we filed cases all over the world, right? I think we asserted 24 patents in China, 13 in Germany, a number of different cases here. We had 2 ITC cases and some district court cases here in the US. So it was an all-out assertion campaign that we had put together, and we actually, we're successful in a number of our cases, right? We got an injunction out of Fuzhou, an injunction out of Germany, and then we had a damages award in the US. And at the scale that we were at, we were able to do that. But for a smaller company that's trying to mount a litigation like this, it's virtually impossible.
Is it correct to say if you do have the resources, then you just want to go on offensive as much as possible?
Hopefully, even if you have the resources, you don't have to get to that point.
Okay.
Like I was saying before, kind of when rational minds meet, on these discussions, generally it ends up in a negotiated license. So hopefully you don't have to get there. But I do think the way that things are moving, you mentioned this earlier, is that the large scale cases are taking on much more of a worldwide perspective at this point, right? It's no longer just an isolated case in the U.S. At this point between the larger companies.
You've been doing litigation for a long time. Is there anything that surprised you about during the course of that litigation?
Oh, there's a lot of lessons learned in that. So, I was kind of helping set up our kind of litigation program in China at the time, and so going over there and kind of meeting with tons of outside counsel. I think at this point now I've been to China about 35 times. On the ground, talking to people there about different IP issues, either talking at conferences or just talking to people and talking to outside counsel and interviewing counsel and all of that. And through that process, I learned a ton about kind of how things operate in China, right? In Chinese litigations. Quite a bit different than they do here in the US. And also, it kind of gave me a much different perspective on how we actually prosecute patents to be able to assert them in China. There's kind of a bit of a different mindset when you don't have the discovery. that you have here in the U.S. when you might have a burden shifting on infringement proofs, but you're not going to be able to just open up the floodgates of information, right, that you can get here in the U.S. And so it is a bit different of a kind of mentality when you actually. I've been trying to feed that back into our claim drafting, right, for especially for China, and taking those lessons and folding it back into the prosecution side.
Why do you think Apple ultimately settled? Because I was thinking they could afford to lose it, and if we're going to go loud, go till the end. What do you think finally kind of made them settle?
I obviously don't know. I haven't. I wasn't in the room on that side. It had dragged out to a point where I think there were real risks moving forward. The case here in San Diego was we obviously settled during opening statements or right after the opening statements in the kind of the main case here in California. So I think there were some real risks, and we had some other cases that were pending. Obviously, we were starting to win. We were starting to get some injunctions. They were having to do design rounds or at least try to do design rounds, things like that. We got the damages verdict. Things were kind of moving to a point where kind of, I think, more real risks involved. And then we had a breach of contract and trade secret case, in San Diego District Court that was moving along pretty well. And that one was gonna start to heat up. So I think, it kind of percolated, or it kind of got to the point where the risks were becoming real.
Even a company like Apple has its limits, I guess. When it comes to one of the things that I guess Qualcomm has to deal with that other patent owners don't have to deal with is the involvement of really, government regulators in their litigations. And, your colleague Mark Snyder said that Apple helped FTC craft bizarre, ultimately ill-fated claims. So while Qualcomm had to deal with Apple, Qualcomm also had to deal with FTC kind of doing Apple's dirty work. I mean, how does that play into your strategy about not can only your business opponent come after you, but they might be able to pressure the government to kind of...
Yeah. So it's obviously that's an example of how it's important for us to make sure to kind of stay out there in the public eye and make sure that kind of our views are seen, right? And we're not just quiet about our business model, the effectiveness of our business model, and the importance of IP rights. And so we have to make sure that we're out there, we're seen, we're advocating for strong IP rights, so that kind of even the government regulators have to think very carefully about what they would, what would happen. What are the repercussions of harming the IP system?
What do you think is the most underappreciated aspect about Qualcomm's business model, and why isn't there everybody on the side of Qualcomm?
Yeah, so I think for a long time, people didn't realize how much we've contributed to the industry, right? We've been kind of behind the scenes more so than out in front. And for example, the technology that we develop enables different ecosystems to thrive, and different kind of applications and things like that to exist. Basically, if you think about it, get into kind of that transition from 3G to 4G, and kind of the advancements in 4G and some of the advancements in positioning that we were pioneering. Without all of that fundamental underlying work that Qualcomm has put in, you wouldn't have apps like Uber. You wouldn't have these other kind of ecosystems that have been built off of the top of it. So it's I think kind of being behind the scenes, people don't understand exactly what we do, and it's something that we need to keep pressing, I think, so that people have more of a understanding of kind of the efforts that the company that Qualcomm puts in to make these other ecosystems viable.
Yeah, I think something cool that your colleague Hunter Yancey, who helped coordinate this interview, does is when he sends an email from his phone, it says something like, instead of from a Apple or from Samsung, it says from a phone powered by Qualcomm.
Yeah, so, that's it. I've got that on mine too. It's from a Qualcomm powered smartphone.
Yeah. So that's good.
Yep.
Qualcomm is also a target of patent lawsuits itself. So you've dealt with on both ends. I mean, what do you think is the state of the patent system as a whole, since you've you experienced it both as a patent owner and a patent defendant.
Yeah. So, so the first few years that I was here at Qualcomm, I really did just work on defending the company in patent litigation. So we had NVIDIA sued us a while ago, and so that was a large scale defensive effort, and we ended up winning that case, which was great. But so I was on the defensive side, and I actually still am, right? Quite a bit. We have cases against us fairly often. So we're on the defensive side. I would say probably more than we're on the offensive side, really, in the litigation context. So as far as kind of the state of kind of IP in general, I'd prefer it swung back a little bit more towards the pre-eBay days and the some of the other changes that have happened, the focus on 101 and things like that. I do think it's in a decent spot, but I also think that we need to be continuously vigilant on making sure that a strong IP system exists, because I do know that there are a lot of people that would much rather not have an IP system at all, basically, because they can succeed through economies of scale and supply chain and kind of usurping others.
Well, at least in the short term, they don't want one.
Yeah. See what happens. So I do think we need to be constantly vigilant about ensuring that we have a strong IP system.
And I mentioned your colleague Mark Snyder. I saw him speak at an IP Watchdog conference, and he talked about the lack of America's innovation policy. I just want to talk about some of the issues you already mentioned, but kind of get your thoughts about them in terms of the innovation policy. You mentioned Qualcomm was able to get injunctions in Germany and China, but America wasn't one of them. What kind of impact does that have that American companies have to rely on China to get injunctions?
Yeah, it would be nice if if we went back to the like I mentioned, the pre-eBay days, and we're really kind of a leader in strong IP. Now there's other countries that are the IP systems, I think, and the remedies are much stronger than they are actually here in the U.S., which is actually unfortunate.
There's an argument about it's called efficient infringement. Some companies, I guess, don't think they should bother worrying about patents until they get sued, and then they could easily resolve them. You mentioned Josh Malone's story and kind of Qualcomm's story in some way. What kind of impact does that have on innovation?
I think it has a detrimental effect on innovation, right? It's another way to kind of weaken the IP system and draw more concern about whether or not you're going to actually be able to reap the benefits of your R&D, right? And with that concern, the system gets weaker. And so I think companies that act in this way, it's just a pretty blatant affront to the IP system in general.
Alongside with eBay, which has basically got rid of injunctions. I guess there are some exceptions. The creation of the PTAB in 2011 in the AIA Act obviously has caused a lot of controversies. Judge Rader called it the death squad of patents. Some think it plays too little of a role these days and want to kind of have new legislation to increase its role. What are your thoughts? What should we have a PTAB? What should its role be when it comes to patents?
I think the original directive of the PTAB, kind of on paper when it was being discussed, with the original legislation, is a good construct, right? It's if it's a much cheaper, more efficient way to test the validity of patents, that's fine. We actually, on the defensive side, Qualcomm has filed petitions as well, and kind of and use the system. And so I think kind of in concept, it's a good system. I think some of the applications of it have kind of maybe gotten a little bit misdirected. I've seen some kind of applications of obviousness out of some of the decisions that I thought were stretching quite a bit. And when you start to kind of misapply some of the laws, I think, and to the detriment of the patents, then I think it becomes an issue, right? It becomes a problem.
And I actually had a previous guest of mine, Professor Yelderman, talked about how the district courts and the PTAB apply obviousness in very different ways. Statistically possible to argue. What about when PTAB should play a role? Like, should it play a role? Should the PTAB, should a defendant have a chance for a PTAB to rule on this patent in every litigation? Should it be only if I get a very slow district court judge? I mean, what do you think about when should it kind of?
Yeah, when should it play a part? I think, I actually think that it really depends on the case, the situation, how the dispute unfolds. I've kind of managed defensive litigations where we decided not to file them, right? And I didn't think it was a good use of our time, good use of our efforts, and so we didn't file, and we just decided to move on in district court. I don't think it should be every case and every situation. I think, depending on how things unfold in the case, how strong is the prior art? Is it, those are all considerations that need to be taken into account, whether or not to proceed with an IPR. And we did it from a perspective of, whether or not we should file or should not file. But I also think that discretion should be allowed, at the PTAB. They can kind of weigh all the factors that are involved in kind of the entire dispute, and is it a good use of their resources at that time, or is it not?
So, do you think we need to restore the American Invents Act for it to play a bigger role?
Maybe in a different way than what's being proposed right now. So, I think some of the proposals that are on the table in the current draft of the legislation are kind of contrary, I would say, to efficient use of a PTAB. I think it actually invites a lot more parallel and serial petitions to be filed at the PTAB, so that companies with deep pockets can drag on litigation and increase costs for a lot of smaller inventors. I think there's a lot of detrimental stuff that's being proposed right now, but I think we kind of need to take a step back and see if we can go back to kind of some of the original discussions.
Some of this we covered, but I kind of want to emphasize them. But let's say there's a company out there who's planning to do business or do a meeting with a company that has a reputation for efficient infringement. What advice would you give them in terms of how to protect themselves?
Yeah. So, that's a hard one. That's a very difficult one, especially if it's a smaller company, right? That it doesn't have the resources. For larger companies, I would say, look, be prepared for worldwide litigation. Be prepared for protracted battle. That you're going to have to take those small victories as you go forward and just keep pushing on. For smaller companies, it's much more difficult. It's you could say, look, be as prepared as you can. Make sure your patents and your reads are as tight as possible, and kind of move forward. But there's a lot of companies that don't have the resources to kind of withstand a long protracted battle, and that's obviously the point, right? Of people that are infringement route, right? Just break the small companies so that they don't have to pay for the IP.
So you were an attorney at a law firm for many years, at a big law firm. Then you moved in-house, and you've become a successful in-house counsel. What advice do you give for other in-house counsel who are listening to this and say, I want to be successful as well?
I don't know. So as you kind of painted I kind of look back at my path, and I definitely don't have a roadmap I could present somebody with and say, hey, look, follow this, and here's where you will end up. But a couple of things I have kind of thought about throughout kind of the course of my career. And one of them is enjoy the work that you're doing at the time you're doing it, right? Enjoy the work you're doing and do it well. If you do those things, and if you really kind of enjoy what you're doing, and you kind of put your thoughts and your time into doing your work very well, it opens up doors that you may not have thought would be there. And then take the jumps when you think you should. So don't be timid to kind of make a leap, when the opportunities present themselves.
That's all good advice. But do you have any specific advice for in-house counsel, I guess?
So specific for in-house folks, I would say understanding obviously the law that you're dealing with as best you can, and understanding kind of the like I was saying before, kind of understanding kind of more from a worldwide perspective, what are the issues that are going to arise with a significant IP portfolio as time progresses. So understanding that, kind of keeping yourself steeped in that in that knowledge base is very important. And then doing and kind of making sure that you get the experiences when you're in house that that you would like to do. Here at Qualcomm, we have a lot of varied experience. I would say, like our in-house counsel gets kind of exposed to a lot of different things that maybe you wouldn't be exposed to as a prosecuting attorney in another company. Some of the licensing prep that we do, some of the litigation prep that we do, some of the other litigation work that we the defensive litigation stuff. Getting those experiences is getting that experience is I think very important for kind of your career development as you move forward.
And now advice to outside counsel who wants to become the favorite of the in-house counsel.
So I did touch on this a little bit before. So a couple of things that I would expect of my outside counsel always is to really understand our business as best you can, right? Not only where we are now, but where we're going, and kind of what the purpose of our patent portfolio or IP portfolio is now, and kind of where is it that we want to take it in the future. So that's the first. But also understanding the technology that we deal with very deeply. So not only understanding the technology also as it stands now, or kind of the history of the technology, but also where is it going, right? Where are we going to be in 5 years, right? Where do we see this going in 10 years? I think is super important for our outside counsel, especially prosecuting patents, to have that mindset and that understanding as we're kind of drafting and going through the prosecution process, because these are assets that we want to be able to use not today, but in 5 years, in 10 years, right? And so having that mindset and that kind of knowledge base, I think, is very important.
All right. Well, thank you so much. Thank you for listening to Clause 8. If you enjoyed this episode, please share it with others and leave a 5-star rating. I'd also like to thank my firm, Harity & Harity LLP, for their generous support. Clause 8 is produced by Great Feeling Studios and Brick Brewer. For more information, visit voiceofip.com. Thanks for listening.